court gave an order that the matter to be mentioned today. Today, the matter came to court. So the Attorney General was held that she was served, she disobeyed, she neglected, she contemptuously failed to appear in court today, and therefore the judge proceeded to allow the prayers as the petitioners sought. Failure for the Attorney General to appear in court on such a national issue is enough ground to remove the Attorney General from office. She needs to come to court. Remember when we had serious Attorney Generals like Professor Githu Muigai, they could come and argue, lose the case, proceed to the Court of Appeal and the Supreme Court. This time, we have an Attorney General who decides to run away. It is a big shame for the office of the Attorney General. Welcome to Court Helicopter Trending Issues. Last week, it came to the public knowledge that Kenya has allowed Americans to build an Ebola quarantine at a military barrack in Laikipia. Law Society of Kenya and Katiba Institute rushed to court, and the court gave conservatory orders. When I talk conservatory orders in a layman's language, it is to stop implementation of what Kenya and America agreed. The court ordered those orders to be served on all the parties, all the people who had been in court. These being the president, being the cabinet minister for health, all the government agencies involved. And by law, all these government officers are represented by the Attorney General. The court gave an order that the matter to be mentioned today. Today, the matter came to court. I want to simplify this thing for every lay person, not lawyers. When the matter came before the judge, the advocate was asked to confirm whether he served the documents. The advocate said he served. And by law, you prove that by drafting what is called a return of service or an affidavit of service. This is an affidavit where you are saying, I so-and-so I'm a process server licensed by the government of Kenya. I was given these papers. I took them to the office of the Attorney General. They stamped, and here is my copy on this date. So the advocate produced that document in court. Then the court allowed the proceedings to proceed. So what is the importance of an affidavit of service? It is to confirm that a party was served, but that party has refused to come to court. Whenever a party is served and fails to come to court, and this is not only in today's matter, everywhere, many of you have been served with the court documents on WhatsApp. Many of you have been brought papers while you are taking tea with a process server. You refuse or throw them away. The court will proceed because it thinks that you have refused, neglected, disobeyed. So the Attorney General was held that she was served, she disobeyed, she neglected, she contemptuously failed to appear in court today, and therefore the judge proceeded to allow the prayers as the petitioners sought. When you don't appear, like when the Attorney General fails to appear, the court takes out that the prayers, the petitioners are unopposed. And that is why the judge has allowed those prayers. Among the prayers are that now all the records, all the agreements, all the transactions, everything related to Ebola and the US government and Kenya must be made public. So those orders have been confirmed. And the court has now moved forward after dealing with the application. There is now the main petition. Normally, an application is what is interim. Once interim orders have been given, then you move to the main petition. The court has given timelines on how to proceed with the main petition, but can the Attorney General appeal? The Attorney General can also appeal. She can rush to the same court to say she could not join virtually. Or two, all the Attorney General's staff were on maternity leave. That's why they were not in court today. Now, after this has come out, we want to clear. There has been rumors that these agreements were done under President Uhuru Kenyatta. Yes, the agreements were done for all laboratories that deal with such diseases. There was no agreement specific to a disease called Ebola. The specific agreement for Ebola facility in Kenya was signed by the Cabinet Secretary Musalia Mudavadi and the Secretary of State Marco Rubio of the USA. The amount was released under President William Ruto. Yesterday, at an interview he had at State Lodge in Warajia, he confirmed he allowed the President of America and the American country to come and put up an Ebola quarantine. Listen to the...
When President Trump asked the government of Kenya to support them by having a center in Laikipia Air Base, I gave the okay because it was an agreement and a partnership with friends who have worked with Kenya for 30, 40 years. The American government has supported us. They have deployed huge resources in Kenya to work with us on HIV/AIDS, to work with us on other diseases. They worked with us.
So this is a confirmation that it is not President Uhuru Kenyatta, it is not the then Minister for Health, Mutahi Kagwe, it is not the then Minister for Internal Security, Dr. Fred Matiang'i, that signed these documents. It is the new government. Equally, the PS for Health, Dr. Oluga, has confirmed that these were agreements that were signed by the current government. The Cabinet Secretary for Health, Adan Duale, has also confirmed that. But the biggest issue is what is the import of the judge's orders. One, the judge has been bold, standing with the public. This is the independence of the judiciary under the Kenyan Constitution 2010. The judiciary is supposed to make decisions without fear or favor. Justice Nyaundi has stood with the public of this country. Two, this facility is in a military barrack. We saw demonstrations, heavy demonstrations in Nanyuki. Is this likely to cause the whole country serious demonstrations? They can. Two, we have seen the state has refused to come to defend itself. The reason why the facility was put up in a military barrack is a serious issue. Are the military responsive to the wishes and the majority of Kenya? We looked at the constitution, whether the Kenya KDF is above the law. We looked at Article 238 of the Constitution of Kenya, which says the principles of national security. The national security is the protection against internal and external threats to Kenya's territorial integrity and sovereignty, its people, their right, freedoms, property, peace, stability, and prosperity, and other national interests. Number 2, which is very important, the national security of Kenya shall be promoted and guaranteed in accordance with the following principles. A, national security is subject to the authority of this Constitution and Parliament. National security, KDF, is subject to this Constitution. This Constitution is created by the people, the sovereign people. They created the courts, and the courts have power over the KDF. It moves on to say, national security shall be pursued in compliance with the law and with the utmost respect to the rule of law, democracy, human rights, and fundamental freedoms. So the KDF are joking. The law and the rule of law binds them. A court of law has issued an order. That is a constitutional court of the High Court. It has issued an order. Any form of defiance will be met by contempt. And lastly, in performing their functions and exercise their powers, national security organs shall respect the diverse cultures of the communities within Kenya, and therefore, this 239, the national security organs are the Kenya Defence Forces, the National Intelligence Service, and the National Police Service. Therefore, they are bound by the law of this country. We know very well they are armed with very serious weapons. But those weapons are bought by the Kenyans. Their service, they are employees of the citizens of Kenya. Article 1 says, we the people, we are the sovereign. We have donated power to 3 arms of government: the executive, the legislature, and the judiciary. The judiciary has pronounced itself. 2, what has happened in court today? Failure for the Attorney General to appear in court on such a national issue is enough ground to remove the Attorney General from office. Remember, the Attorney General's office, the Attorney General does not have security of tenure. The security of tenure is on the president. She can be removed from office. It is a big frustration for Kenyans who pay the Attorney General to come to court, represent the government, and the Attorney General fails to appear. From court helicopter, we give the Attorney General 0. She needs to come to court. Remember when we had serious Attorney Generals like Professor Githu Muigai, they could come and argue, lose the case, proceed to the Court of Appeal and the Supreme Court. This time, we have an Attorney General who decides to run away. It is a big shame for the office of the Attorney General. Wakili Danstan Omari.